Very good. Very good.
Yes.
Now we come to a comparison. I am sitting in Saudi Arabia, so I would like to have a comparison between the this Kenyan privacy laws and the Saudi PDPL. Can you throw some light on it?
Yes, I can. And I think I made that attempt some time back with regard to dividing lines and common threads between Saudi Arabia and Kenya. On close scrutiny, I realized that the Saudi Arabia PDPL is very particular about public interest and
Right,
national security.
right,
It's
right.
more aligned to that
Yes,
compared to the Kenyan Data Protection Act. The Kenyan Data Protection Act has a provision that provides that public interest and national security can be exceptions to data protection. But they are not emphasizing on that so much, even on cross-border. Saudi Arabia emphasizes that a lot. Even on
right.
cross-border data transfer in Saudi Arabia, they are very particular that
Yes,
national interests,
yes,
public interests, and national
yes.
security are
Right,
factors that have to be considered in
right.
that instance. The other point of divergence, which I think I noted, was on posthumous data privacy.
Yes, right.
The PDPL KSA, Kingdom of Saudi Arabia, is has provisions for posthumous data privacy.
Right.
Kenya has zero provisions on posthumous data privacy. Kenya only targets natural persons and living persons.
Yes, yes.
Once you go post-mortem, there is no protection in that line. And I think I also have a paper on that, which I think I'll share in future. I'm very, very critical of the fact that the Kenya Data Protection Act should be having a law that governs posthumous data privacy.
Right.
Because in this fourth industrial revolution, most people leave a digital print. And this
Yes.
digital print might have some economic value and
Right.
financial value.
Right.
We care what your heirs and next of kin would feel like or how they would be affected by this digital print you leave. So it's a
Right.
concern that we have that kind of law going forward. Some similarities, we both have authorities. Saudi Arabia have the authority, SDAI, SDAIA.
Yes. Sadaya.
Kenya
Yes.
have
SDAIA. Sadaya. Yeah.
SDAIA. Kenya have the ODPC.
Right.
So they both have authorities. They both have data subject rights. They both govern data subject rights. And they make people obligated to answer to data subject rights. They all follow the data protection principles as
Right.
common threads, which they do. So ideally, those are some of the things which I think I spotted. And I want to give a disclaimer that my list is not exhaustive. It is merely guiding in terms of this academic session that we're trying to really just create awareness regarding these
Right.
differences.
Right. Correct. Correct. I agree. I agree
Yes.
with you. Okay. Let's move to data subject rights. How
Yes.
empowered are Kenyan citizens under the law? Just shed some light on it.
Um, okay, based on the argument I made as we were starting, I think the levels of awareness, if I'm to rate between 1 and 10, I think we are at 6 out of 10
In
in
terms of
terms of
awareness. In terms of awareness.
awareness of the Data Protection Act.
I think it is
Because,
better. I think it is better. I have seen much below this, maybe three or
no,
four or two, in terms of awareness. Especially countries with large population. For example, India. It's a huge
yes,
population, 1.4 billion population. So
yes,
if you go, then the awareness of such things are very, very minimal. Yeah,
very minimal.
yeah.
Okay, so
Yeah.
I think,
And there is a lot of avenues to work on it. And I always, in my talks with the privacy professionals and the guys who are in
yes,
this field, to create the
yes,
awareness.
yes,
Yeah. So they must work very hard on creating the awareness among the masses.
yes,
Whose data is being utilized?
yes.
Yeah.
So I think Kenya is making good strides on that end of awareness. The data commissioner is making good strides in terms of awareness, and evident of the information, education, and communication materials that are coming out of the data commissioner's office. There are so many even cartoons made for the public to understand. So it's not purely legalese in terms of awareness. They have tried to even translate the language of the law into the national Kiswahili language
Yes.
to enhance and bolster awareness.
Very good.
Based on the matters that are reported to the ODPC's office for breaches, I think I can confirm because it's on average, it's almost 10 or 20 matters that get reported for breaches of personal data. I think Kenyans are coming so robustly in terms of vigilance on data protection law.
I see.
I can confirm that our awareness levels are above average locally.
Yes. Very good.
For
Very
the
good.
Data Protection Act.
Very good.
Yes.
Very good.
Yes.
Now, coming to a very important aspect in personal data privacy, which is the sensitive data, like
Yes.
health or biometric information. Does the Kenyan law treat it differently?
Kenyan law ideally treats health data as sensitive data.
Right.
GDPR also, I think, they also treat health data as sensitive data. The Office of the Data Commissioner came up with guidance notes for processing of health data. And there's a reason why, because this is very special data and requires very special procedures for handling. So yes, health data is treated differently to other personal data because it is sensitive data. And it is the kind of data where you need more than one to process. So if you just, for instance, for processing of vital interests, you need contractual obligation other than consent, because most people will scream, start with consent, get the consent of the patient before you handle the data, not knowing that consent is the weakest of all
I agree with this.
law.
Yeah.
Yes, is for processing of health
Right.
data. So yes, we have guidance notes on processing of health data, just to show that the Office of the Data Commissioner saw into it that health data is special data and sensitive data and requires a special procedure for processing. So yes, it is.
Very good. Now, can you share some example of enforcement action or case study that demonstrate the law's impact in Kenya? Briefly.
I talked about the OPPO case, and I don't want to take my listeners aback because I'd already hinted on what the OPPO case was. OPPO Kenya case was a case where OPPO Kenya, a company marketing phones, processed data of a data subject without their consent nor knowledge to market their phones on Instagram.
I see.
So this data subject saw their photo on Instagram marketing Oppo Kenya products, and they felt aggrieved. So they decided to approach the data commissioner, and it reported the breach, the personal breach that had occurred. So the data commissioner investigated and confirmed that indeed there was a breach, use of images and photos unlawfully and illegally. And they gave a penalty to Oppo Kenya of 5 million Kenya shillings, which I think locally that is like $50,000, which is quite a huge amount. And it was a penalty that is a very deterrent penalty, because I think Oppo Kenya was also a repeat offender in terms of these data breaches.
Yeah.
So that is one case, Oppo Kenya case. The other case, which I think also got global attention, is the WorldCoin case. WorldCoin came around Kenya with the orb. If you ever heard of the orb, they take the iris of the data subjects in exchange for $7.
I see.
And this went on without a DPA. It went on without proper consent.
I see.
And all the normal rigors of procedure from the Data Protection Commissioner. So when the matter went to court, it was argued that the getting of consent from data subjects by giving them $7 is not free, voluntary, and fair consent.
Fair, yeah. Right.
That is consent that is bought.
Yeah.
And
Right.
that is consent gotten through fraud.
Right.
So it is not free and voluntary consent. So there wasn't any consent. That was the holding of the court. There wasn't any DPA, and the court directed that all the irises, biometric data that were collected from the data subjects, they were given a 30 minutes period to destroy all that data and apologize and follow the right procedures if they need to go ahead with the WorldCoin issue of issuing WorldCoins in exchange for biometric data. So the WorldCoin case is a classic example.
Right.
It is cited as ODPC versus Tools Against Humanity and two others in the High Court of Kenya, 2024. Yes. So those two cases are classic examples.
Very good.
Of enforcement actions.
That's good.
Yes.
Now, looking ahead, what do you see as the next phase for Kenya's data production landscape?
So I think I spotted three things which I think are of a major concern to me. AI.
Right.
The embracing of AI is a fact which we won't ignore, and we cannot ignore because AI is here to stay. And so far as we can argue that it has come to take our jobs or any other thing, the mishappenings it has come with, there are more advantages than disadvantages with the coming of AI. So going forward, where do I see the data protection landscape? I see a scenario where data protection is going to embrace AI. And this is something which I think even Lucient AI is doing. There are people who are called Signatu are doing. There are people who are called Security Ops are doing. One Trust are doing. So that is where we are headed to.
I see.
The other thing I saw was more lawsuits are going to come about because of more awareness and robust civic education going forward. And lastly, I also saw that more data controllers and more data processors are going to embrace data protection more and are going to register more because registration is the first step to compliance. So those are the three things which I think I noted are going to change going forward. Yes.
Very good. Since the time is running out, we'll try to wrap it up fast.
Yes.
You have given excellent insights, Mr. Timothy, on this
Yes.
Kenya as compared to GDPR and Saudi Arabia also. Finally, what's your advice for organizations in general starting their compliance journey in Kenya?
I think my advice would be to engage an expert on data protection issues because cross-border differences in legislation and
Right.
processes and procedure are quite a challenge. You need
Right.
somebody with local knowledge to take you through what you ought to do on the ground. The other thing is registration as a data controller or processor is just the first step towards compliance. It is not compliance. So I think that would be my advice to people who want to come and trade, probably even Saudi Arabia or India to Kenya.
Right.
Engage an expert like Privacy Pulse Consulting Inc. And they'll take you through what you need to know as a business person or even a trader or even a health practitioner.
Right. Thank you so much.
That would be my advice.
Very good. Thank you so much, Mr. Timothy. You have given in a short time. You have given a deep insight in the Kenyan laws, and I Privacy Pulse look forward for such sessions in general for Africa also. And as we were discussing one time, then there is a lot of trade also between this region, Saudi Arabia, and the Africa region. So it will be. I think next time we will try to have some more details on this cross-border data transfers. So how we can these two regions can work together and comply on these cross-border data requirements. So again, thank you so much. Thank you so much for your time, and thank you, viewers. And we will be coming again next time with such insightful sessions. Thank you so much.
Thank you so much, Mr. Anis. Thank you.
Bye.
Bye.
Bye.